Well, earlier this week, bond insurer MBIA won dismissal of a lawsuit brought by around a dozen banks, including UBS and Bank of America, some big names there. Well, the banks were claiming MBIA's restructuring was intended to defraud policyholders. Well, MBIA's share price soared on that news, perceived as good evidence. You can see on 1 week up almost 7%, trading near a high. It's still trading near this high. And the day this lawsuit was dismissed, I sat down with MBIA's attorney Mark Kasowitz. But our next guest says this case is far from over. With me is the counsel for the other side of this. This is attorney Robert Giuffra from Sullivan Cromwell. He is joining us now, and he's the lead counsel for banks in these two cases against MBIA and also a partner at the law firm. So let's talk a little bit about this. We had Mark on earlier. Clearly, MBIA considers this a victory. Many investors responding quite bullishly to the news, but I do know that you say it's far from over. So where do you go from here?
Well, Lisa, we have two cases against MBIA, and the Article 78 case, which is the case against the department and MBIA, challenging the legality of the department's decision. That case is well going forward, and in fact, we're putting into the court next month a stack of papers this high, which will include reports from some of the most experienced people in the country in this area, including former superintendents of insurance, bank regulatory experts, people who are experts in insurance, people who know about the valuation of structured products, and we feel very strongly about our case. The other case, which was the fraudulent conveyance case, we are going to the New York Court of Appeals. The decision below was decided by a 3-2 vote. 7 judges have looked at this issue. 4 have ruled against MBIA. 3 have ruled against the banks. So the highest court in New York will decide the issue. Okay,
so that will be appealed. Now let's talk a little bit about the banks involved in this. Some of them have dropped out, right? JP Morgan, I believe, Barclays, CIBC, they've settled, or they are settling with MBIA. Any idea why, and do you expect any more to adopt that approach?
I can't speak to the other banks, but the 12 banks that are in this case are committed 100% to the lawsuit. More importantly, this case is not just about the banks. This is about everyone who has insurance with an insurance company that's regulated by the New York Insurance Department, health insurance, property insurance, and it includes all sorts of people who own these structured products, which are universities and pension funds. What the insurance department has done here in an unprecedented way is allow an insurance company to divide itself up into a good insurer and a bad insurer. And imagine after the Katrina situation, if a property company had divided itself into all the people along the Gulf Coast and everyone else. Clearly, that would not be permissible. We think this transaction is illegal, goes well beyond the insurance law, and we think we're going to win.
Well, along those lines, I want to bring up another company that is similar to MBIA in terms of what it did. AMBAC, another monoline insurer. I want to clarify one thing I had said on Tuesday. AMBAC actually wanted to adopt a very similar structure or restructuring to MBIA. Now, I had said that a judge made a ruling rejecting AMBAC's plan, but in fact, it wasn't a judge, it was an insurance regulator. You're talking about New York State Insurance Department. In AMBAC's case, it was Wisconsin. I want to ask you, how do you compare these two companies and the various outcomes, the different outcomes?
Well, the Wisconsin insurance superintendent did it exactly the right way. He brought all the parties in, had a public hearing, public proceeding, brought all the interested stakeholders, all the policyholders, and they attempted to negotiate a resolution. What happened in New York is really tragic. This was done in the dead of night without any notice, any public hearing. It's all been done in secret. And in fact, all this is the insurance department doing a transaction that benefits MBIA and its shareholders. And the stock price has gone up, at least for now. But the big winners here have been so far the executives who paid themselves millions of dollars in bonuses for getting this fraudulent transaction through.
Now, I mentioned early in the week that we had counsel Mark Kasowitz, who's representing MBIA. He was on earlier in the week. And I just want to share a statement that he had given us that day. Here's what he had to say. He said, "The statements and the fact that seek to disparage the determination of the superintendent of insurance are frankly wrong. If he were here, I could point that out to him." And he is referring to you, Bob Giuffra. Well, now that you're here, what do you say about that? I mean, the other point that Kasowitz made is that they're making good on all bondholder claims that are made against both companies. But the question is whether or not they can continue to do that. And that is certainly an interesting thing. Here we're seeing a case with the banks. When do the investors or the bondholders step up?
Well, in terms of the question about the evidence, as I said, there will be a mountain of evidence. The problem that we have in this case is that MBIA and its lawyers have blocked out the evidence. They do not want news organizations to see the truth, to see the facts. In fact, the New York Times wrote a letter to the court asking that the files be unsealed. MBIA and the department have opposed.
Bob, I'm sorry, this is a letter.
This is a letter that I wrote to the judge. It discusses emails that Jay Brown received and the insurance department received.
Jay Brown, the president of MBIA.
Exactly, and they are concealing this information from the public. They do not want the truth to come out. And what we are going to do, and we'll have a public trial in this case, and we will have the public will see what the evidence is. There is overwhelming evidence that this is an illegal transaction and it should never have been allowed. And in fact, right now the insurance department has filed an appeal to try to stop the judge's order, which would have allowed us to see internal department emails amongst Mr. Donalo and others as to whether they were biased against the banks. The judge said, yes, if there are emails showing that this was a preordained, put-up result, you should get those emails. Well, you know what? The department is fighting hammer and tong to allow those emails to come into our possession, much less to come into your possession. I urge Bloomberg to write a letter to the court asking that these proceedings be made public, because the public has a right to know. This is an issue of enormous importance.
Bob, thank you so much for joining us today. This is attorney Bob Giuffra. He's a partner at law firm Sullivan Cromwell, representing the banks in their case against MBIA. Certainly more to come on that front, Bob. We'd love to have you back as developments arise.